Go ahead.
All right, good afternoon, and thank you for joining us for the 6th Facebook Live video. We're wrapping up week 3 in Van Winkle's 8-week virtual Lunch and Learn series. It will continue with these videos until November 19th. As part of this series, we are presenting on a range of estate planning topics, and today we'll be discussing what is a durable power of attorney and do I need one? My name's Koral Alman. I'm here today with John Kelso. John and I are attorneys with the Trust and Estates Group at Van Winkle, and our practices focus on estate planning as well as trust and estates administrations. Today, as I mentioned, we're going to be discussing durable general powers of attorney and why you should consider adding one to your estate plan. We do want to say at the top that our discussion today is about general North Carolina law and our own experiences and practices. This presentation is not intended to be legal advice, and it should not be taken as a recommendation for any particular situation. So even though many people consider general powers of attorney to be a one-size-fits-all form document, they're not, and you really should talk with your attorney about your own specific circumstances before relying on broad general information. So with that, I'm going to hand it off to John to kick us off.
Thank you. So first, we want to start off with a description of what is a durable general power of attorney. And this document can go by many different names that usually all mean the same thing. You can call it a general power of attorney, a durable power of attorney, durable general power of attorney. Most people think of it as the financial power of attorney, although it covers much more than just finances. It generally names somebody who would have the power to manage most of your financial and other sort of non-healthcare affairs. Most often this is during your incapacity, but not always during incapacity. That person who you appoint in the document is called your agent. So throughout this presentation, when we are referring to the agent, that means the person who you have named to act on your behalf in the power of attorney. A couple of other notes. The power of attorney is effective and valid only during your lifetime. It ceases instantly at the moment of death. Of course, then the will or other estate documents would take over. Go ahead, Koral.
Well, so we're also really going to drill into what does that durable word mean in the durable power of attorney. And that's a question we get a lot by our clients, and it's not just a valid question, it's an important point with respect to your general powers of attorney. So a durable power of attorney is one that will continue to be in force after such time as the individual whose document is what we call the principal becomes incapacitated. That's what makes this such a critical tool in your estate planning toolkit, is the fact that if you later become incapacitated, a durable power of attorney will continue to be operational during that time. So it allows someone to manage your finances at such time as you may truly be unable to do so for yourself. So as John said, it doesn't have to be during a period of incapacity, but the important component of this is that it can be during a period of incapacity. It's also a very useful aspect because it helps to avoid the necessity of a court-appointed guardian who might otherwise be required to manage your affairs. And that would be a court proceeding where the court literally appoints a guardian who will help you manage those finances. Whereas if you have a general durable power of attorney, you would have someone in place who could do that for you without the involvement of the courts.
Okay, next we're going to talk about what authorities the agent has usually under a general power of attorney. So what powers does the agent have that they can exercise on your behalf? And under North Carolina law, there are some powers that can be given generally in the document, just by a broad sweeping statement. And there are some particular powers that have to be spelled out explicitly if the agent is going to have that power. And usually those are the types of powers that you would want to be a little more circumspect and think about before granting them. We'll talk about those. So the general types of powers are things like opening or closing bank accounts, writing checks against a bank account, brokerage accounts, handling investments, directing investment accounts, receiving money from those accounts, paying bills, filing tax returns, and then, things like being able to call up and deal with the utility company on your accounts, or being able to call up and deal with any other account or subscription, or other things that you have made that are financial or business arrangements. Selling property, both real property, your house, for example, or things like a car or household assets. And also sort of providing a customary standard of living, taking care of you and also your family. So that also means that there's some overlap with the healthcare agent who may be making healthcare decisions about you if you're incapacitated. I do want to mention, though, that the powers of a general power of attorney apply to things that you own personally, as opposed to, for example, things that are titled in a revocable living trust. So if you have a revocable living trust and you have assets titled in that trust, the power of attorney does not control those trust assets. The trustee controls those trust assets. And also, for example, if you are the president of a company or you're the manager of an LLC, the power of attorney probably does not give you the authority to step into the shoes of that job description, for example, as acting on behalf of a company.
So that leads us to the next question, which is, when does your general durable power of attorney become activated? What triggers that? And the North Carolina general statutes provide that a general durable power of attorney is effective immediately upon execution, unless your document says that it's going to become effective at a future date or contingent upon some future event. So what does all that really mean? And the important, we're talking a lot about incapacity. So usually the principal can specify in the document either when it becomes effective or can allow specific people to determine when it becomes effective. But if you say in it, it's effective upon my incapacity, and you don't exactly define how we determine that, you don't give some sort of parameters or a direction as to who would determine that, then our North Carolina statute says it's effective after an examination of the principal by two individuals who are either a physician, a licensed psychologist, or both, that the principal is incapacitated. Which then gets us to the next level, which is, well, what does incapacitated mean? And in that regard, we're looking at a determination that the patient is unable to manage property or business. That's a pretty, hard line. We're not talking about someone who has difficulty managing their financial affairs, or that it's sometimes they can do it and sometimes they can't. We're talking about a whole hog. They are unable to do this. So it's really important that we exactly define how this document comes into effect. If we want it to go into effect immediately, that's statutorily provided. But if we don't want that to occur until some later date or time, what's triggering that? And it's really our general recommendation that we often tailor these so that this is in line with a prior version of the statute, that they become effective when recorded with the Register of Deeds in the county where the client resides. So that gives us a good kind of trigger activity, right? It has to be taken to the Register of Deeds and recorded before it's an effective or an activated power of attorney. And I'm going to let John discuss when do we actually record it then, or how does that next step proceed?
So the recording of the document could be handled either upon specific things that are spelled out in the power of attorney, or based on directions that the principal, the client in our case, has given to us if we are holding the power of attorney, or if the client themselves is holding the power of attorney. If they have the original document, not just a photocopy, but the original, then they can control who has physical access to that document and could take it to the Register of Deeds office to be recorded. So, often the key determiner there is, where is the original signed document, who has access to it now, and who would have access to it if you, the principal, become incapacitated. and are in the hospital and are not able to get into your house or get into your safe deposit box. So that's really sort of a logistical question that we try to discuss with each individual client. I'm going to also jump into the discussion of how the principal and the agent share their authority. Because a common misperception among our clients is that when the power of attorney is activated, becomes effective, and the agent now has power, well, does that take away the principal's power to act for themselves? And the answer is no, absolutely not. It's a coextensive power. So even though the agent now has authority to act, the principal, to the extent they're able to anyway, also legally has the power to act for themselves. So, of course, in many situations of incapacity, it's a very gray area whether someone's incapacitated or not. You know, it's not black and white, either you're totally capable or totally incapable. And so by activating the power of attorney, that causes a situation where the principal can still do those things that they want to do or are able to do, either on their own or maybe with a little help. But the agent also has the same powers to handle those things that the principal is not able to or forgets to, etc.
So on the flip side of the activation question is, when is your general durable power of attorney terminated? When is it no longer in effect? And there's three big buckets that we talk about when your general durable power of attorney would terminate. The first is if the principal revokes it. You know, I give John authority to do something and I decide I don't want to do that anymore, I can revoke that authority. The second is if the agent dies, if the person I have appointed is no longer obviously able to do that because they have passed, that power of attorney is no longer effective. And the third is when the principal dies. And this is a really important concept that we regularly have to kind of walk through with our clients. You know, we've already talked about the fact that your incapacity is not, if it's a durable power of attorney, is not going to be a terminating event. But your death is, and John mentioned this a little bit earlier, but it's pretty easy to see if someone has been managing you know, their mom's affairs for years. They've been the agent under a power of attorney and they have been paying the bills and handling all sorts of things. And then mom dies. There's often this, you know, memory, muscle memory of, oh, I just got to keep paying those bills. But like John mentioned earlier, that's when the will kicks in and we need to have an executor appointed, or if it's the case of an intestacy, an administrator appointed to actually handle those financial matters. But it can be a confusing concept when you've been paying mom's bills for, you know, 10 years, and now your authority under that power of attorney is cut off. Because as soon as the principal, as soon as the individual who is appointed the agent has passed, that power of attorney is terminated. I also want to talk really quickly about limited powers of attorney. This isn't as much of an issue as it once was, but a lot of banks and financial institutions previously were requiring folks to get limited powers of attorney. So I have a general durable power of attorney appointing my brother to manage my affairs. He takes it to the bank. The bank then says, well, we actually need you to sign one with us. It was their own little fiefdom sort of situation, but it seems to have sort of worked itself out under the new statute because there are provisions that require third parties to accept a power of attorney unless they have a good reason to refuse it. And then last little add-on, we talked about this a little bit before, but there's an important interplay between your general power of attorney, your financial power of attorney, and your healthcare power of attorney. So your healthcare power of attorney is the document that will appoint someone to make healthcare decisions for you when you are unable to do so for yourself. That can be the same person as the agent appointed under your general power of attorney, but it need not, and it often isn't. So, you know, it's important to understand how those two documents, if it's not the same person, interplay. When we prepare those sort of documents, we regularly include language that permits the coordination and cooperation between those two different agents, and include explicit language saying if the healthcare agent says she needs to have this surgery, then the agent under the general power of attorney can't undercut that, veto it, et cetera. In practice, though, it does occasionally turn into a fight. You know, you can conceive of the situation where a healthcare agent believes that nursing assistance is really, really necessary, but the general power of attorney agent needs to sign the contract to pay for it. And if they're not going to sign it, we're kind of, you know, we're stuck in limbo. So it's a really important concept to make sure you're discussing that if you're going to appoint two different people in those roles, how are we going to have these folks resolve their differences? Do they work well together as it is? And in the event of a conflict, how are we figuring that out?
So the choice of who you want to name as your agent is just so important, because, you know, we sometimes talk about these things as if everything is just cut and dry and fits into neat little boxes, and
Right.
the statute provides an answer to every question. But that is just so far from reality. The person you name as your agent is going to have a lot of discretion and a lot of flexibility. And they need to be, that needs to be somebody who is not just going to sit back and wait for things to happen that they respond to, but is going to proactively seek out what they need to do. What needs to be done for the principal, the person whose affairs I'm managing? What does the law allow? What does the law constrain me from doing? Because that person just has a very wide-ranging fiduciary authority, and the document can't provide answers for every little situation that comes up. I also want to mention, we've mentioned a couple of times in passing that under the new law, or under the new North Carolina law, North Carolina updated our general power of attorney statute in 2018, became effective in 2018. So what that means is that we had a statute prior to 2018, and then effective January 1, 2018, the old statute was completely replaced by an entirely new statute. So any document that was signed prior to 2018 or under the prior law, it is still effective. So don't worry. It's not like your power of attorney is worthless now, but it's now 2 years out of date. It's using sort of legal terms that are no longer part of North Carolina law.
Right.
So it is a good idea to go ahead and update those things to reflect the new statute, the new terminology, some of the new rules. If we had more time, we could sort of point to some specific differences in the old law and the new law. They're fairly similar. There are some important differences, but they're details. Anyway, that's what we mean about the new law. So we've talked about how the power of attorney relates to the principal's own authority, to a limited power of attorney, to a healthcare power of attorney, and also want to mention again the revocable living trust that I touched on before. So if you have a revocable living trust, then the agent who is named in your power of attorney does not become the trustee. They don't step into your shoes and control your trust. That would be the person that you named in your trust agreement as the successor trustee. So often those two people are the same, those two different roles, the successor trustee and the agent in the power of attorney, because they're performing pretty similar roles. Most of the time, that authority is when you're incapacitated. The trustee would be managing anything that's titled in the name of the trust. The general agent would be managing other things. It is sometimes useful, though, particularly for wealthier clients who have assets that are titled in their trust. They might want one person or group of people to be managing, say, their family business interests, their investment real estate, or a large brokerage account that would be titled in the trust. So you'd have one group doing those things, and maybe another person handling the more sort of routine day-to-day financial affairs that don't necessarily involve investment decisions about big dollar assets. So it can be used to bifurcate these kinds of roles. But it's also something that, if you name different people in those roles, again, you have to think about, well, how is that interplay going to work between these two people if all of a sudden they don't get along?
It really just hammers home how important the decision is as to who you appoint, both for your agent, but also as a successor trustee for your trust or other fiduciary roles that you may appoint people to. We also touched on this earlier on in our presentation about there being general authorities that are authorized under your power of attorney, and then there are some that need to be specifically authorized. And we're going to touch very briefly in our remaining 5 minutes or so on what some of those specific provisions are, is the kind of the big ones that we see quite often. The first I want to mention is what we are referring to generally as like gifting provisions. So we can authorize in your power of attorney the authority for your agent to make gifts from your assets. And that gifting authority can be very, very specifically tailored. So you could have it such that you could be making gifts to a spouse, children, grandchildren, charitable organizations, religious organizations, educational organizations, or any combination of those. And you know, it's really just what we lay out in the document is what will dictate that. We can also provide in that document some sort of guidance as to how much they can gift to those people. There's a concept of, you know, your historical giving. How if you've given $1,000 to charity X down the street every year, at Christmas you give them $1,000, and if you would like that to continue, your agent can be authorized to continue gifting that's consistent with your prior gift history. We can also include language that can limit gifting to ensure that your agent does not make gifts that might have negative tax consequences. And that's a whole, I mean, we could spend an entire presentation talking about estate tax and gifting considerations, but the idea is we don't want someone gifting so much money that they impact your estate tax or the inheritance tax, if we're using more colloquial terms. Now that would only impact, at least currently, a small subset of the population, but you never know when that might change. So the big takeaway here is that if we want to include gifting provisions, it has to be specifically authorized. But if we specifically authorize it, we can tailor it very, very specifically to what you would prefer as your gifting authority.
And the underlying reason why most of these specific powers that have to be spelled out are written that way is that keep in mind the agent's fundamental duty is to act in the best interest of the principal. That's a fiduciary duty, to act for someone else's interest, not for your own interest. And generally speaking, giving away someone's money is not really in their best interest.
Right.
But often the principal would want that. In addition to the situations that Koral mentioned, one that I've seen regularly, I'm sure many of us have, is where you are helping out family members, either adult children. Now, taking care of minor children who you owe a legal duty to support is not really gifting. But helping out your 25-year-old child who is still sort of trying to find their feet financially in the world, that's a gift that can't be made unless the power of attorney authorizes it. Or taking care of, for example, an incapacitated sibling, helping them out financially here and there. Those are the kinds of things that need to be allowed specifically. Another one of those powers is, this is always a frightening one, the ability to change beneficiary designations. Generally speaking, your agent is not allowed to rewrite your will, but so many of your assets these days are controlled by beneficiary designations, not your will. We covered that in another presentation. So you might have a bank account that is joint with right of survivorship, either with your spouse or someone else. You might have bank or investment accounts that are set up as pay on death to a named beneficiary that you filled out on the bank form. And so you have to think about, would you want your agent to have the ability to set up those types of arrangements or change them if you have already got them in place? I think many people initially respond and say, no, I don't want my agent to have that kind of power. But there are occasions where it does come in handy in unanticipated ways. For example, for tax planning, it may be good to sever a right of survivorship account. Or I've seen this many times where people didn't think that their accounts had beneficiary designations on them, but they or we later discover that indeed they had named a beneficiary and they want to get rid of it. So should the agent be able to get rid of it, which is what they think the principal would have wanted? Or maybe the agent is engaging in some sort of estate planning simplification and wants to create a beneficiary designation for an account that follows exactly what the estate plan would do. It does not change the result of who would get the money, but it means that this money would avoid probate, be quicker and cheaper to get to the beneficiaries. You know, should the agent be able to do that? Same question about, you know, retirement accounts, 401ks, IRAs, annuities, even life insurance. Should the agent have the power to modify those beneficiary designations? And that can also be spelled out very explicitly. For example, yeah, they have unlimited power to do it, or they have power to do it, but only if certain other people consent to it. And if you're going to give them the power to exercise that authority in a way that benefits themselves, the agent himself or herself, that has to be spelled out. So not only do you have to say, yes, they can change the beneficiary, you separately have to say, and they can change it in a way that benefits themselves. So that, you know, the law is very careful about that, very cautious, and I think rightly so. It's a dangerous power to add, but it's obviously a very useful, flexible power to add to the document. I do want to mention there are a few protections. I'm not sure I have time to do that. I think I need to move on. There are a few protections in there that the law provides. Go ahead, Koral.
Yeah, well, it's good to think about these things both from the perspective of an agent's ability to perhaps do nefarious actions, but also the fact that they can provide authority for an agent to do things that are truly for the benefit of the principal, or like you said, to simplify their estate plan. So we've got just a minute here left, and I'm just going to touch on one more specific authority, and that's the authority to modify trust documents. This can apply to either revocable or irrevocable trusts. It can allow an agent to amend the trust agreement, to add property to the trust, or to even create a trust if one does not already exist. We generally include a prohibition from the agent from withdrawing property from the trust. So if you have a trust and you've already titled assets in that, we'll generally include a provision prohibiting the agent from withdrawing property that's already in the name of the trust without the authority or the approval of the successor trustee. Now, if they're the same person, it's pretty easy to get authority from yourself to do something. So it's just another important thing to be thinking about, kind of tying back to the same threads we've been talking about all day, which is that this is a very important position. It can allow an agent to modify your entire estate plan if granted the authority, and it's just something we need to really be thinking about. I think with that, though, we can probably wrap up.
One last word in there that I hope we have sort of educated you. I certainly feel like a power of attorney should not be viewed as just a simple form document that you download and print out and sign. There are a lot of really important powers out there that can be very helpful or cause a lot of problems for you or for your family. So I think those need to be evaluated individually, but it's an extremely important document to have as part of your overall estate plan. Thanks for joining us.
We'll have one more. The next group of folks will be presenting next Tuesday at noon, and we hope that y'all will join us then for that presentation. Thanks.
Bye-bye.